delighted to be here and delighted to be talking to you about state constitutions. Neither Bob nor I are experts on Rhode Island constitutionalism, and so what we're trying to do is to provide a sort of broader national framework within which you can think about what you're doing in this particular state and make, we hope, a better decision by virtue of attending forums such as this. Let me begin by noting what we're doing here today. We're sitting here discussing whether to call a convention to amend or replace the Rhode Island Constitution. Yet most of us could never imagine ourselves at a similar conference deciding whether or not to amend or jettison the federal Constitution. It's a rather striking contrast, but it isn't hard to understand why. As Bob mentioned, most of us revere the U.S. Constitution. We have a National Constitution Center in Philadelphia celebrating the founders. And most of us think we couldn't do a very good job of improving on their handiwork. But somehow we don't feel the same reverence, the same attachment to our state constitutions, whether you're talking by state of New Jersey or yours of Rhode Island. Rather, we think of these as rather prosaic documents, can-do documents, things which are going to enable us to structure our government that will serve us better, things that are going to enable us to have a better state. In another sense, of course, we're not here of our own volition. We're here because the Rhode Island Constitution specifies in Article 14 that every 10 years, if a convention question has not been on the ballot, every 10 years, it will be placed on the ballot by the Secretary of State. This is not totally distinctive to Rhode Island. 13 other states have a similar sort of provision. Article 14 further mandates that if a simple majority of those voting on the question favors a convention, then a convention must be held. Again, think of the contrast with Article 5 of the federal Constitution. In order to get a convention at the national level, you need the concurrence of 2/3 of the state legislatures, something that's never happened. And so we have the single convention at the national level. We have multiple conventions in the various states. This requirement of a periodic popular vote is a relatively recent addition to the Rhode Island Constitution. It was imposed by constitutional amendment in 1973. In fact, neither of Rhode Island's earlier constitutions, at least at the time that they were drafted, had such a requirement. Indeed, neither of those constitutions expressly authorized the legislature to call a convention at all. Indeed, in the late 19th century, the Rhode Island Supreme Court said the state legislature cannot call a constitutional convention, a decision that wasn't overturned in Rhode Island until 1935. Adding this requirement of a periodic vote seems to me a very wise decision, because it doesn't create an obligation so much as it creates an opportunity. I wish we had this similar provision in my own state. For the requirement has the effect of forcing or encouraging the citizens of the state to think seriously about their government, what's right, what's wrong, and what can be done to improve it. Now, this may all sound very familiar to you as citizens of the state, but a moment's reflection reveals how unusual this is. Compare Rhode Island's experience with constitutional change with constitutional change at the national level. Rhode Island's had 8 constitutional conventions. The federal government, of course, has had only one, and Rhode Island didn't even bother to attend. Rhode Island's current constitution, ratified in 1986, has been amended with more frequency than the federal Constitution. Federal Constitution, 27 amendments. If you take out the Bill of Rights, which is sort of part and parcel of the original founding, That's one amendment about every 13 years. Very difficult to change. On the other hand, if one compares Rhode Island's experience with that of other states, the disparities may not seem so stark. Most states have had multiple constitutions. Rhode Island's had 3. The total number of state constitutions, 144. So it's right in the middle of the pack here. Louisiana, as Bob mentioned, had the dubious distinction of having 12 constitutions. It's sort of a tradition there was like Mardi Gras. And state constitutions are modified, amended frequently. Alabama's 1901 Constitution has been amended over 900 times. I was down there talking to them, and they said that our Constitution looks like Moby Dick with a couple whaling chapters taken out. California's Constitution almost 500 times. What we really have then is sort of 2 different constitutional traditions. At the national level, we value stability and continuity. At the state level, we value change and experimentation. This reflects actually a conflict of views, if you will, at the very point of the founding. James Madison emphasized the importance of constitutional stability and the dangers of frequent change, interesting the people too much in these highly controversial issues. In the states, however, we look not to Madison, but we look to Thomas Jefferson. Jefferson thought that it was important to get people involved, participating in resolving constitutional disputes, both to ensure that constitutional principles were adhered to, the people would guard the constitutional principles, and also to allow growth in response to changes in circumstance and with regard to changes in attitude. Jefferson said, why would I want to wear as an adult the coat that I wore as a young boy? It won't fit. The situation has changed and we must adapt accordingly. In fact, this idea of a periodic vote on whether to have a convention is something which Jefferson himself had originated. Now, of course, every state has its own distinctive constitutional history. Rhode Island, for example, unlike any other state, for a while had a constitution that wasn't a constitution. After independence, Rhode Island retained its 1663 charter from the king as a constitution. By the time it was finally replaced in 1843, it had served as the fundamental law of the state, or of Rhode Island, pre-state and state, for 180 years. In addition, no other state has simultaneously had 2 constitutions with 2 competing governments, but courtesy of the Dorr Rebellion or the Dorr War, depending on which historian you talk to. You have the citizens of the state, stymied by the legislature in their efforts to hold a convention, held an extra-legal convention. They drafted a constitution, they elected a governor and a legislature, and so you had simultaneously 2 legislatures and 2 governors operating in the state. If you're one of these people who thinks that one government is more than enough, imagine this. What that extra-legal convention did, however, is sort of interesting because it also points to the way in which constitutional conventions can promote change. What happens, eventually the Dorr Constitution, the so-called People's Constitution, is not recognized by the federal government, but the threat of this was sufficient to get the legislature in 1843 to call a convention and to meet most of the concerns that spurred the Dorr Rebellion. Of course, these are merely historical examples. For most of its history, Rhode Island has had other distinctive features. State legislature selecting the state judges until relatively recently. Until 1909, there was no gubernatorial veto at all, and of course, as you all know, there's no item veto even now. But what's important here is not whether Rhode Island is distinctive or not, but the fact that you get to make your own choices. And so what I'm going to talk about primarily is the sort of choices that are involved, the sort of process. John Marion already talked about this in some detail, and in some instances I may be repeating him. It's always the disadvantage of speaking last. But the process by which things are done. Rhode Island, like all other states, have chosen procedures for constitutional change that give great power to the people. First of all, the people by majority vote get to choose whether or not to have a convention. And they may well decide not to pursue constitutional reform. Thus, although Rhode Island has had 8 constitutional conventions, voters have at times rejected convention calls, most recently in 1994 and 2004. The people also choose the delegates. The people also get to ratify or reject the convention's handiwork. And Rhode Islanders, again, have used this opportunity to make significant choices. Thus, in 1898 and 1899, Rhode Island voters voted down a series of amendments proposed by a constitutional convention. More recently, in 1968, they rejected a proposed constitution by a 4-to-1 margin. Maybe there's an ornery streak in the state. Note that in making these choices, the people are acting directly, not relying on their representatives in the General Assembly. Put differently, the government does not control popular access to the fundamental law. This is true in other states as well. As I mentioned, 13 other states have joined with Rhode Island in creating a periodic popular vote on whether to hold a convention. 18 additional states have sought to ensure popular control over constitutional change by adopting constitutional initiative for proposing amendments. 2 states allow the voters to call for a constitutional convention via constitutional initiative. Yet the alternative that Rhode Island has chosen may be the wisest course. At least in part, this is because of the indirect effects that the periodic popular vote can have. Those in power often oppose a constitutional convention because they fear that constitutional change may undermine their positions or reduce their power. The impending periodic vote on a convention, then, creates an incentive for those who hold authority to address problems that might otherwise encourage voters to vote for a convention. In that sense, then, one sometimes gets needed reform even before the convention vote occurs. Rhode Island has also made another wise choice. To assist the people in deciding whether or not to call a convention, it has provided in the Constitution for creation of this bipartisan preparatory commission. Other states have established similar commissions by statute or by executive order. What do these commissions do? Well, in other states, when you are going to have a convention, what the commissions do is they engage in major research with regard to the problems that exist, with regard to how other states have addressed themselves to those problems, and assess the success or failure of those approaches adopted in other states. Sometimes these commissions produce voluminous reports. Before the 1963 convention, I believe it was, in Michigan, The commission produced 4 volumes, each of which looked like a telephone book with commentary and analysis. But this is all to the good. There's considerable evidence that these commission materials play a major role in assisting delegates in developing solutions to the state's problems, and voters in deciding whether to call a convention or to endorse the convention's handiwork as well. The people's representatives also get to make some important choices. In most states, the legislature establishes the system of delegate selection, determining how many delegates there will be and the constituencies from which they will be selected. Most states, like Rhode Island, use legislative districts for selecting delegates in order to avoid legal challenges under the Voting Rights Act or under the Supreme Court's one-person, one-vote standard. State legislatures, again, in most states, Rhode Island here an exception because they've constitutionalized it, can schedule delegate selection to occur simultaneous with the vote on whether to have a convention or to have it occur after the decision has been made to have a convention. Rhode Island has chosen, of course, the latter approach. The former approach, simultaneous selection, can result in a great deal of wasted energy. You campaign to become a delegate, and there's no convention. You're elected for the party, but the party's been canceled. On the other hand, the advantage of the simultaneous selection is usually there's a great deal of turnout. If you have a special election, turnout tends to be low, and those who are selecting the delegates may be a unrepresentative sample of the population. Most states also determine whether the convention delegates will be selected in a partisan or a nonpartisan election. If one chooses to select delegates in a partisan election, this obviously enhances party control over who gets chosen, and typically the conventions, when they're formed, organize themselves along partisan lines the same way you would find a state legislature organized. This also means typically that the partisan composition of the convention reflects the partisan composition or tends to be similar to the partisan composition of the state legislature. If you don't have partisan election and have real nonpartisan election, which the parties don't dominate, you get a different delegate mix. Sometimes with happy results, sometimes with not happy results. In Maryland in 1967, for example, candidates ran without party labels and not without much party input into who was running. The result was a convention dominated by political amateurs. They produced a constitution that political reformers rejoiced in, and they lost by about 2-1 vote in the ratification vote. How you choose the delegates determines to a considerable extent how the convention will operate and the sorts of proposals that will emanate. A final choice, and this is, I think, a crucial choice, addressed by state constitutions in some states and by statutes in others, involves eligibility to serve as a convention delegate. Some states impose the same eligibility requirements as for state legislators. Other states permit all eligible voters to serve as delegates. Whichever of those choices is made is not likely to have a crucial effect. But what may have a crucial effect, some states, either by constitutional provision or by statute, prohibit any person from simultaneously holding more than one state office. In at least some states, this has been interpreted to mean that if you are serving as a legislator, or a mayor, or a official within the executive branch, you cannot simultaneously serve as a delegate. If you wish to serve as a delegate, you will have to resign your post. Most state office holders are understandably reluctant to do so because being a convention delegate is a temporary job, because the job that they're vacating may not be available to them when the convention is over. The effect of a ban on dual office holding, thus, is to prevent leading political figures in the state from serving as delegates. This has both positive and negative consequences. The negative is that the convention loses the political experience and leadership skills of those serving in state office. Although, in many states that have this, former legislators and former governors do serve in conventions. But from my point of view, the positives actually outnumber the negatives here. One positive is that the opportunity is available for a whole new group of individuals to play a part in the politics of the state. Montana in 1971, when they had their convention, had this ban on dual office holding. At the time of the convention, the Montana legislature had 4 women in the entire legislature. Legislators not able to serve, of the 100 delegates at the Montana convention, 19 of them were women. Opportunities became available. Another positive is the new perspectives that these delegates bring to issues confronting the state. Delegates serve for only a limited period of time. They don't have to worry about re-election. If they have not served in government, and many of them have not, they are not wedded to the way things have been done in the past. And because they don't have to worry about the short-term political consequences of their actions, they can bring a different perspective to the issues they confront, thinking not in terms of the next election, but perhaps the next generation or the generations after that. I got a signal that my time is short, so let me just make a couple comments about what happens within. Don't listen to that? Well, I saw people walking out. I thought that was within the convention itself. Again, important choices. Delegates choose how to structure the convention, how the work will be organized, and how it will be accomplished. They choose who will preside over the convention, and they create the convention's committee system. And committees in constitutional conventions, given the short time frame within which conventions usually operate, are crucially important. With regard to leadership of the convention, the delegates may choose a person of stature who's seen as above politics. Think of the selection of George Washington in the Philadelphia Convention of 1787. Or the delegates may choose as president, the leader of the majority party in the convention. If this latter course is adopted, the convention may well operate like a state legislature with. He has a different watch than you do. The last point I will say, though, is that going back to what happened in the 1986 convention, you notice that there were 14 separate proposals put forth to the voters. This choice as to how the handiwork of the convention will be submitted to the voters is a matter that the delegates decide themselves. The advantage of multiple submissions like this is that if there is a controversial issue or two, you don't want that to sink the entire Constitution. Separate submission has the opportunity, therefore, to separate the controversial from the non-controversial and allow progress to be made. You've noticed that almost all the examples I've used have related to conventions, 1970s, 1960s. That's because, as was noted, Rhode Island is the last state to have had a convention. In part, it reflects a view that conventions are expensive, which they can be. In part, it reflects a suspicion that the same folks who dominate ordinary politics in the state will dominate politics in the convention as well. And a part of it may just be an interest in piecemeal change through amendment rather than more comprehensive change. But this piecemeal change isn't altogether satisfactory, oftentimes. Sometimes a state's problems require more comprehensive solution that upsets the status quo. And sometimes it may even be worthwhile simply to change the political dynamics in the state. As a supporter of constitutional reform in Louisiana once said, if it ain't broke, break it. Whether there's a need for this within Rhode Island, I leave to you, but I hope the discussion is helpful in making that decision. Thank you.